Thanks so much. Hi, everyone. Hope you're having a great Friday. So, the topic that I'm going to be talking about today is the precarious boundary between work and play. And it comes up more than you'd think in my practice. Some pretty interesting stories that I always get calls about. And a lot of that is a pretty tricky scenario where something's happened, an employee's done or said something, and we're trying to figure out what the employer should do next, whether that's take action against the employee, whether that's supporting the employee. And there's a real line, there's a bit of a blurred line between what is something an employer can regulate and what isn't. And it's one of those things that's definitely developing over time. So we're going to explore some of the grey in what the tests are that have developed over time and some of the grey in this. So what I'm going to start with is talking about out of hours conduct. So some of that, those fun, Christmas party calls that I sometimes get of inappropriate behavior at Christmas parties and where the line is with that. Social media is increasingly one of those tricky concepts. When can we regulate conduct by social media when so many people have Facebook accounts and Instagram accounts and employees are talking to each other outside of work hours? When is there enough of a link to work for us to be concerned about that conduct? The next topic we're going to talk about is romance at work. Why are there lawyers in my bedroom? So the nature of, I guess, the policy for employers around how do we deal with this and where's the line? It's, I think, something that we grapple with as an employer at Herbert Smith Freehills. So I'll talk a bit about some of the different approaches that are taken in that space. Couldn't have a conversation today from a lawyer without talking about the liability of employers. So I'll touch on that briefly. And feel free to ask questions as we go through today. I'm quite happy to answer those on the run. So please feel free to put them in the chat and I'll make sure we get to them. So I probably don't have to tell you all, but workplace behaviour is obviously essential for employers. And I think increasingly workplace behaviour as a broad concept, not just talking, I guess, about sexual harassment, which has been much more of a focus over the last couple of years since the Respect at Work report. I think this concept of workplace behaviour in a broader sense is starting to be more of a board agenda item. And obviously there's the obvious cost, I guess, of this. There's legal liability for unlawful conduct. There's, wanting to be an employer of choice and having a good culture. There's obviously the cost and productivity damage of whether that be legal or absenteeism or relationships with external clients. But I think increasingly what is really funding a lot of developments in this area is the reputation. It is that workplace behaviour, whether that be sexual harassment or other types of conduct, given the impact that those sorts of actions can have on a business's reputation, increasingly that is being seen as an ESG issue. And this is where I think employers are getting a lot more sophisticated with how they're dealing with these sorts of issues and thinking about these things in a bit of a different way. And I think sexual harassment is one component, which I'll talk about today, and that is really a topic in itself. So we'll touch on that a bit later. But I think suffice to say that we're in a bit of an interesting time. We've had, I guess, the Me Too movement. We've had a lot of push and change since the Respect at Work report came out. And I think certainly what I'm seeing in my practice is that behaviour that perhaps has been condoned for a long time, people are speaking up more about that, which is a good thing. It does mean that HR practitioners are increasingly busier. But we're constantly having to investigate matters where we're looking at, has that manager, I guess, crossed the line? Or is it just, they can improve their management of their people? So I think there's a real, I don't know, I see it as a real wave at the moment of push towards not only people speaking up about behaviour that impacts them, but also bystanders in the workplace being much more willing to speak out about certain workplace behaviour. And that's leading to a lot of behaviours being uncovered that is a good thing, that we are now having to deal with. The tricky thing that I want to talk about today is what the line is with certain out of hours conduct. And the way I think about this is a few things. There's, by out of hours conduct, I'm meaning conduct that isn't necessarily in the workplace, but there's still some sort of link to the workplace. So think about conduct, the classic one, conduct at a workplace Christmas party. Conduct immediately after that Christmas party. Criminal conduct in personal time that might have the impact of damaging the reputation of the employer. Conduct in shared accommodation on a work trip that isn't actually during work hours, or perhaps physical altercations between co-workers at the pub at 6 o'clock on a Friday night. There's some obvious ones that fit neatly into the test I'm about to talk about. There's others that are a lot more grey, and this is where I think whenever I get these issues, I have a look at the test, I have a look at the case law, and I draw the line as to whether I think it's something that can be regulated or not. The general premise is that employers don't have the right to regulate or control out of hours conduct. But there is some circumstances, narrow circumstances, recognised by the courts and the commission, where certain out of hours misconduct may constitute a valid reason for dismissal in an unfair dismissal context. And the key case in this area is Rose and Telstra. So Rose and Telstra, what that said was an employee's employment may be terminated for out of hours conduct, but there's a few limbs to this. So the first is where it's viewed objectively, the conduct is likely to cause serious damage to the employment relationship, number one, or the conduct damages the employer's interests, or where the conduct is incompatible with the employee's duties as an employee. So it has to be of such gravity and consequence to indicate a rejection or a repudiation of the employment contract by the employee, but absent those kind of serious circumstances, we simply can't regulate it as an employer. Now, to give you an example, in Rose, this was a while ago, 2 employees, they had a fight, there was a stabbing involved, it was quite serious. They were attending a work trip at a regional town. Neither were on call, neither were wearing their work uniform. Yes, they were both employees, but the employer was unable to show in that proceeding that there was damage to its reputation, or that the dismissal or that the conduct objectively viewed was likely to cause a serious damage to the relationship with the employer. So there wasn't enough in those circumstances. And certainly since Rose, that's kind of the case that always gets quoted as being the seminal test. There have been various examples that have developed since then. Now, Sydney Trains is a more recent case, and that kind of, I guess, noted the Rose test, but took it a little bit in a different way. And the test has been referred to, certainly Rose is the most seminal test, but what the full bench in that case said was the conduct has to touch on the employment. And this is, you've kind of got to look at all of the circumstances. So what's the nature of the out of hours conduct and what was involved? Where did it actually occur? In what circumstances did it occur? What was the nature of the employment? What was the role and the duties of the people involved? What was the principal purpose of their employment? What is the nature of the conduct of the employer's business? What did their employment contract say? Did it regulate this at all? What was the effect of the conduct on the business? and what was the effect of the conduct on the employees. Looking at all of that, there will be a requisite connection to employment where the results of the conduct directly impact on the employee's ability to perform work, or where the employee's role had inherent requirements or essential requirements with which the out-of-hours conduct is directly inconsistent. So to give you an example, this employee had twice been reported with alcohol in his system. On the occasion in question, he'd reported to work less than 24 hours after being found to have drunk driven in his private time. He was a train driver. In those circumstances, given the high degree of independent judgment he needed to make in his role, high degree of decision making, and he needed to comply with safety regulations as part of his role, and that he had failed to assess his sobriety, there was the requisite test found, and ultimately the dismissal was fair because of the materiality of the safety risk that his conduct posed. So whether you take any of these tests, I think it's really clear that just assessing the whole thing together and the circumstance and really looking at all of those factors that I mentioned before, it's definitely a weighing exercise. So it sounds really easy, right? But each circumstance is different, and this is where we start to get into tricky territory. The way I think about the conduct, whenever I'm assessing this, I look at things differently. So you've got social media. Increasingly, I'm having complaints or investigations that are looking into, certain groups of employees, like Facebook Messenger, for instance, or WhatsApp, where conduct is happening and complaints are being made through that forum. It might be that one person's at work at the time, but the others are at home, and having to assess, well, is there the requisite link? Out of hours conduct, Christmas party is always in, I think. The increasing ones that are difficult are where you've got an after party of the Christmas party, for instance, and I've had one of those recently. Work conferences and the events with them are also part of that. And again, we'll talk about some of those examples in a minute. So the obvious one is conduct that is inside the workplace and in the usual course of duties. Of course, that's something we can regulate. Out of hours conduct is the next limb of we need to go through that Rose test to assess whether it is out of hours conduct that can be regulated. And then the outer limit to that is social media and the developments in that, and we'll go through that in a minute. But I think the difficulty with some of this when a case comes across my desk is, obviously I give legal advice on whether I think it does have the requisite connection to work. That will not, I guess, an employer needs to weigh that up with the ultimate decision as to what approach they're going to take, because in some instances the risks of reputation, notwithstanding the high legal risk that there will be, the dismissal will be unfair, might outweigh that, and that's particularly the case with certain types of sexual harassment or sexual assault type offences. So let's talk about the grey area. So the grey area, for instance, might be, and this is obviously not a complete list, but unofficial work drinks after the Christmas party. It's very common. It's why the warnings that usually employers send out remind people of their obligations in relation to work events. And these kind of unofficial events would hopefully be captured by your policies. A visit to a co-worker's home during a lunch break, or a layover between flights for flight attendants, or a hotel shared by employees on an employment related trip are just some of the ones where there's this grey area where you need to look at the test in rows. We've already gone through this, so I'll just give you some examples of how we apply it. So the interesting thing about the test in rows is that there have been some decisions that have said that the gravity of where you've got particularly serious situations, and I'll give you some examples of them in a second, where you've got violent or offensive conduct, or where there's some sort of really serious conduct committed against another employee, then that will be justification for the dismissal for out of hours conduct. It's not necessarily, it's of such a gravity that it leads to a repudiation in the employer's employment, and it kind of gets you out of the test in rows in many ways. So to give you an example of this, where there was a recent case. I often find that domestic violence is a really difficult issue. Domestic violence incidents obviously are usually in someone's private time, but depending on the role that they play within the organisation, can actually be of concern to many employers because of the role that they play. So to provide you with an example that was recently handed down, Lonnie and the WA Council for Addictions, this guy played a pretty pivotal role in managing residential treatment services of an organisation that provided services to the public, to those affected by alcohol and drugs. And he was charged with breaching some restraining orders against a fellow employee that he was in a relationship with. There was also a whole lot of conduct that was verbally abusive, and he was found to have engaged in verbal domestic violence against her. Now, all of that obviously was outside of work hours, but the role that he played in the organisation, in many ways, charitable organisation that provided those services to the public, in the commission case, which was an unfair dismissal, and the question came up, was there a valid reason to terminate him? The commission found that there was, for two reasons. First, there was a code of conduct requirement in their kind of overarching policy to refrain from activity where the personal or professional conduct is likely to compromise the fulfillment of his professional responsibilities. Now, this was a clear regulation of his personal life. But the code of conduct extended to that to the extent that it impacted the organisation and the fulfillment of his duties. And the commission looked at what he did, looked at the link, looked at the fact that it was domestic violence and how serious it was, and decided that the direction that the employer made in this situation was actually appropriate because of his role in overseeing those services. He breached the direction by engaging in the conduct. He also breached, there was also a failure of him to disclose a prior restraining order that was in place against him in relation to that person, and charges that were filed against him in relation to that. So in all the circumstances, there was enough of a link and there was a valid reason. You look at that decision against the Public Employment Office one, which was a similar, I guess, situation where there was a corrections officer who was convicted following assaulting his wife and daughter. And in that case, the full bench of the New South Wales IR Commission found that he wasn't able to establish a sufficient connection to the employment relationship to cause the kind of damage required by Rose. So domestic violence, I think, is a really tricky one, and I think is going to really turn on the number of links to the workplace, but also the role that the employee is playing. I think in Lonnie, that person's role was pretty central to the support that he was giving to those people. So there was that direct link, whereas perhaps a corrections officer, not so much. The other interesting cases involve, I guess, physical altercations. So, and there's been a number of them. In Farquharson and Qantas, an employee's conduct during slip time. So I guess the rest time between international flights was found to be sufficiently connected to their employment, and that actually signed an acknowledgement that they would observe the employer's policies during that time. There was another one recently involving another train driver he had a physical altercation at a railway station on the way to work with a member of the public, and he was in uniform. He was standing at the platform when that occurred. The dismissal ended up being unfair for different reasons. But the important point here is that the Commission found that the incident had a sufficient connection to work. He was in uniform, he was on the way to work, and it was directly linked to his role as a train driver. So I think all of the circumstances, I always look at everything and look at whether there is that sufficient link. The other interesting thing about this kind of more serious edge of conduct is in sexual assault cases. So sometimes we've had situations where an employee will make a sexual harassment complaint against another employee at the same time as there are sexual assault proceedings, criminal proceedings on foot with that employee. And the employer has to make the decision to investigate the sexual harassment, which they do. They get to the end of that investigation. They have to decide whether to terminate that person, notwithstanding the fact that there's criminal proceedings on foot. And we have had unfair dismissal cases that have gone through the Commission where the dismissal has been upheld based on the findings of sexual harassment being quite serious, notwithstanding that there was this other criminal proceeding hanging there, and that's one of the more difficult situations that sometimes we have to deal with. So social media. I think increasingly social media is another grey area. We've seen in the Fair Work bullying jurisdiction, one of the elements to that is the conduct has to be at work in order to be captured by that jurisdiction. And there have been quite a few cases in the Commission on that. It's just interesting to see how that's developing. Obviously, if both employees are at the workplace together, it's going to be sufficient connection. But what if one's at work and one's at home? What if they're both at home and they're texting each other? This is where we start to get into looking at the grey area. And I think with increasingly employees working from home in, post-COVID, we all have flexible workplaces now. I think this is the area where we're starting to see some developments. And this is particularly the case where the media itself is used to perpetrate the conduct, whether it be sexual harassment or other things, or the more controversial one where employees are expressing views that are in direct conflict with the values of the organisation. And the problem with that from the employer perspective is that the employer can be attributed with those comments in the wonderful world of media, 24-hour media that we have, because the employee is being seen to be a representative of the employer to the world at large. And there's a number of different high-profile examples of this. I think we've got some of them here. You look at the termination of SBS journalist Scott McIntyre after he refused to put take down some controversial tweets that he made about Anzac Day. Now, the matter was settled in that situation, but it's just an example of where this has come up. There was a case that made its all the way its way to the High Court involving a public servant employee who posted tweets that were critical of her employer, their policies, the government and its policies, as well as members of the parliament. And that explored the boundaries of freedom of political communication. Or you take the termination of Israel Folau from Rugby Australia after Folau took to social media to share his religious views, which Rugby Australia alleged were homophobic in nature. I think this is really one of those areas that still we haven't, I think the Folau case also settled before we got a final hearing, and we really haven't got a whole lot of decisions on the boundaries of all of this. But what is clear is that social media is becoming more prevalent. There's an increasing expectation, I think, that employees are aware of the risks and pitfalls associated with their use. I think employers are greatly assisted by making sure that policies are very clear as to about what conduct is regulated by the employer, and making sure that they're clear about what the expectations are of employees. And obviously, when an incident does come up, it's worth having a look at the existing case law at the time to kind of guide the employer on the legal risks associated with what we're dealing with. You look at this example, for example, two very different situations, two kind of similar situations that have come to very different decisions. So, O'Keefe on the left, what happened was the employee put up this Facebook post, didn't name the employer, and threatened a fellow employee. The Commission held in this circumstance that the dismissal was justified, despite that the post was made on a personal computer out of work hours. And there was a particular emphasis on the threatening nature of the post that commented, and the Commission said, look, the separation between home and work is now less pronounced than it used to be. You compare that to the very infamous now hairdresser case on the right, which is Fitzgerald, where the Commission found that the dismissal was unfair because the employer was unable to show that the social media post of this one caused damage to the employment relationship itself. Now, it was vaguely critical of the employer. It didn't identify the employer, or it didn't make threats of fellow employees, and therefore it didn't meet the bar. I think in cases involving social media, there has been some recognition by the Commission that Facebook posts can be regulated. It, of course, depends on the circumstances, but a mere kind of belief that that Facebook is private is now not going to be enough anymore. I think the fact that an employee is putting up a post, even if their whole Facebook is private, the fact that they might have colleagues who are friends, they might have clients who are friends, I think doesn't get them out of this conduct potentially being regulated. But of course, you need to look at the specific conduct, specific post and the circumstances to evaluate that. The tricky things with social media, I think, it does blur the line between your work and personal life. Here are some of the questions to think about. Do you have colleagues following you on Facebook, Twitter, LinkedIn, or Instagram? And are you connecting with them via Snapchat or WhatsApp? Do you invite colleagues to be social media friends and followers? And how do you choose to friend or defriend them? Could your actions be seen as ostracizing, bullying, or victimizing one or more of them? The number of platforms, I guess, that exist and some of the complexities with all of this mean that really it is worth considering in detail each business's policy around social media, because I think this is an area where we're already seeing an uptick in complaints being made about these forums, and it does get quite tricky. These are just some of the things, I guess, that have come up in cases as being as leading to workplace conduct issues. So unfriending or unfollowing colleagues, complaining about the workplace. Obviously, we've talked a little bit about that, and you'll notice that it's a very fine line in terms of being able to, I guess, show the Commission that there is reputational damage caused by those very public posts. It is an area I think that's still developing. Discriminating against, insulting, or giving feedback to a colleague may be unlawful. Posting a photo of a colleague without their consent may breach privacy. And then there's various things around clients that are also worth looking at. So I think increasingly it's an area that gets a bit tricky. The one that often comes up is from an employee perspective in responding to allegations involving social media is, well, I have a right to privacy. what the Commission has said, it's an older case, but I think it still holds up, is that the applicant is perfectly entitled to have personal opinions, but they're not entitled to disclose them to the world at large, where to do so would reflect poorly on the company or damage its reputational viability. So the fact that in this case, the applicant made Facebook comments in their own time is of no consequence. It's not when the comments were made which is important, but the effect and the impact of those comments on the respondent, its employees, or on the new employee that's important. So I think that gives helpful context. In this case, the employee was quite critical of a third-party organisation which the employer had a professional relationship with, and they made sexually suggestive comments to another employee, and both of those things were found to be a valid reason. There was a social media policy in place which addressed appropriate use, and the person was aware of and trained in that policy. I think DP Sams's comments were particularly interesting. He said that the dismissal of the employee would have been fair even absent the employer's policies, because the employee hardly needed written policies or codes of conduct to understand and appreciate that the kind of sexual comments made were grossly offensive and disgusting, and were more likely than not to cause hurt and humiliation. Also, given the comments about the third-party organisation would have had an adverse impact on the employer's relationship with that organisation and damaged their wider reputation, the Commission upheld the dismissal as being fair in the circumstances. So just a bit of a snapshot of social media policies and what should be in them. Being really clear about the statement of purpose, the application of scope of covering your entire workforce, the conduct that's covered, what is prohibited, what is permitted in terms of work versus personal. One of the questions I had recently was, does an employee own their work email address? And can we get into those emails while that employee is on extended leave? The email system itself, if the policy is worded correctly, that is still a work system. So certainly work email addresses or work email inbox are something that the company owns, not the employee. It's obviously different to a personal email address, but I think setting out in a policy some guidelines for what is acceptable and what isn't is really important, and giving some examples so people know how far this goes. Having a look at passwords and security around those and putting that in, putting in something around how you're going to monitor communications, particularly given in some states there is surveillance legislation that requires certain steps to be done. So making sure that you're ticking those boxes of surveillance legislation, how people can report policy breaches, and then the consequences of the breach. I think if you are setting up guidelines for this, it at least gives employees some indication of how what they're expected to do and what is okay and what is not okay. Making sure they're trained in it is really essential. Making sure that you're enforcing it when things happen. But also, obviously, all of this is going to be tested against the testing rows. So just remembering that we can set up the policy, we can train people in the policy, which is probably the best thing you can do. But then when things happen, we need to go back to the testing rows and assess all of the circumstances to determine the legal risks around terminating for that conduct. Now, the business might step back from everything and go, that is such a serious circumstance, we're going to take the legal risk, notwithstanding that there is a higher one in these circumstances because of the detriment to our reputation, because of the impact on our customers, because of the impact on our employees. But at least being cognizant of those legal risks around around whether, if this went to the commission, whether how this would be treated is helpful as part of your decision making. So I think it's really important to review and update your policy as required, to train, to educate the workplace, to monitor the use of social media, to enforce the policy, and to review relevant contracts. And often contracts themselves will have pieces in there around that you must follow lawful and reasonable directions, that you can't engage in conduct that's incompatible with your duties as an employee, aspects like that that you might also be able to draw on in dealing with situations. Romance at work. Why are there lawyers in my bedroom? I love this one. So the general rule is that a direction from an employer not to have a personal relationship in the workplace, often called a bonk ban, will generally not be a lawful and reasonable direction. It could actually give rise to discrimination type claims on the basis of lawful sexual activity. Personal relationships do happen in the workplace, and sometimes those can lead to situations where the employer can regulate that conduct. So, for instance, an actual or perceived conflict of interest. So, let's say there is a procurement officer who has some sort of personal relationship with an external organization that they actively deal with, and the procurement officer is the one who is determining whether or not they get the work. That could be a conflict of interest that exists. The other piece is sometimes when things go wrong, there are sexual harassment allegations that are brought out, or bullying. Given this, it gets quite difficult. I think a number of years ago there were some high-profile incidents like some of these on the screen, where employers looked at this issue and went, how far can we go here? And different employers have taken different approaches. So, for instance, we at Herbert Smith Freehills, so most employers will, I guess, have a conflict of interest policy that will regulate the requirements for employees to disclose conflicts of interest that might or actually exist, and then set out processes for the business to work through what that means. There's obviously, all employers should have workplace behaviour policies or some sort of policy that builds in a prohibition on bullying and sexual harassment. Those are pretty commonplace. But I guess what employers have been doing, certainly in the last 10 years, is looking at, can we go one step further? So, for instance, many employers a number of years ago introduced new policies that required the disclosure of personal relationships. So it wasn't a prohibition on those, but it said if you are in a personal relationship, and usually a romantic one, where you are in a relationship with these types of people, we need you to tell us what that is so we can record it on a register, we can be aware of it, and we can manage that situation if things happen or if things go wrong. What that enabled businesses to do was look at whether there was a conflict of interest in the circumstances, and if there wasn't, just manage or monitor the relationship in case things went wrong. The benefit of that is, I've run a lot of investigations involving conflict of interest matters, and what I often find is that people just aren't able to identify whether it's a conflict of interest or not, even if in the most kind of obvious ones, like the procurement example that I mentioned. You'll find that people just don't recognize that as a conflict of interest. So what that policy is doing is putting that back on the employer to assess whether there's a conflict or not, rather than putting it on the employee to self-diagnose that themselves. So that's one example of policies that exist. Otherwise, people generally deal with it under general conflict of interest policies or workplace behaviour policies and manage it when things go wrong. But I think it's an interesting one that that comes up, and obviously different employers have different instances, but there have been serious, quite public examples where quite senior executives have had relationships and it's become public and it's impacted the reputation of the business. So I guess this is just one of the ways that people are dealing with these things. So liability of employers, I wanted to talk as an example about sexual harassment because this is obviously one that has developed a lot recently. And I guess we're expecting to see a lot more activity in relation to sexual harassment given the new positive duty that is in the Sex Discrimination Act now, but it's being enforced by the end of the year. And the Australian Human Rights Commission has a whole lot more powers to be able to enforce the duty. So for those who haven't looked at this in greater detail, there's some great guidance material on the AHRC website giving you a steer for how to comply with this positive duty. But I thought I'd talk about this because this is an example, I guess, of where out of hours conduct that relates to sexual harassment may come across your desk. I just wanted to talk about a couple of the changes. So Section 28B of the Sex Discrimination Act is the prohibition on sexual harassment. And there have been some changes to the Act to broaden the offences to cover a lot broader relationships than simply employer-employees. So it's trying to really replicate safety law where it's a variety of different people. So employers, employees, workers, and persons conducting a business or undertaking. It's trying to make all of those people, I guess, liable for a broader range of working interactions. So take these examples. This is some of the examples that would be covered. An employer against an employee or a prospective employee, which is a more obvious example. An employer against a host employer against labour hire workers at that workplace, or employees of a client's site against labour hire workers, or even volunteers against employees. There might not be any working relationship between the people involved, but it can still be captured by harassment laws where there's a connection with one or more of the people being a worker or a person conducting a business or undertaking. So think about a contractor, a supplier, or a member of the public sexually harassing, for instance, a direct hire employee. What that really means is it's important for your policies to really regulate, I guess, a broader array of people than the traditional employer-employee. There's also, of course, vicarious liability provisions that regulate when an employer will be liable for an employee's conduct if the employee commits an unlawful act of sexual harassment or one of the other harassment type offences that are in the legislation. There has to be some sort of connection to the employment of the employee and the duties of an agent as an agent. But there is always the possibility, the Commission and the courts will look at is whether there's that connection to work, and what the employer has done to discharge their positive duty will assist in their defence of a vicarious liability claim. I think the increasing trend in sexual harassment and the increasing expectation of the Commission in this sense, the Sex Discrimination Commissioner has been quite clear that merely having training, merely having a policy, merely having training is not going to be enough to meet that duty. You're really going to need to look at the different facets of your framework to look at how you are discharging that duty. And that might be risk assessments to determine the risk associated with these types of behaviour and how you are putting in controls from a safety perspective to manage those risks. It might be how you are dealing with bystander training and changing your existing training frameworks to really encourage a speak up culture. It might be other mechanisms like how you're broadly all of your cultural initiatives, and how if you've got a particular workplace which is very male dominated, how you are manages, how you are what your initiatives are to change that, to make it more equitable, given that gender inequality was found to be one of the key drivers of sexual harassment in the Respect to Work report. So really thinking, I guess, about the framework for managing this quite holistically is going to be important to those defences, and also the defence of any allegation that you've breached your positive duty. So just in terms of there's various different types of ways that an employer can be liable for an employee's conduct. But really, as I said before, the key is to make sure that you've taken reasonable steps to prevent the unlawful conduct. So some of the things I was talking about before with sexual harassment are going to go into your defense of these sorts of aspects. So for those who haven't looked at this in greater detail, it is worth looking about what your organisation has in place to be able to build the framework that it has to deal with this sorts of conduct. And I think initially it was sexual harassment focused because the Respect at Work report, but certainly a lot of organisations are thinking about this in a much broader sense of prohibiting inappropriate workplace conduct, because it not only goes to it goes to a lot greater things of what an employer wants to be. So being an employer of choice, not only complying with legal obligations, but creating a good culture. And many of these things, I'm sure, are things that businesses already have on foot. It's just, I guess, putting them all together to build that framework. The other piece that I guess has been a bit of a change has been complaints procedures. So I think most employers will have policies, they will have some sort of speak up line, whether it be anonymous reporting or to a dedicated person. I think the way businesses are moving on from that or developing that process is um, is to look at the incidence, I guess, of these sorts of behaviors occurring. I think increasingly people are looking at a zero. We haven't had any sexual harassment complaints. That does not necessarily mean that conduct is not happening. So there's an increasing push, I guess, in various forums for people to look at, I guess, training workforces more on bystander training so that people are more willing to speak up. Having clear complaints procedures there ready for people, which most people do, but then also changing the way that complaints are dealt with. So the traditional, I guess, approach of a HR person, for instance, investigating is still happening, but people are thinking about support a bit differently. They're calling some of the new types of investigations, which actually we're training some organisations on, is victim-centric investigation. So thinking about the levels of support we're giving to people through the process, thinking about perhaps having a separate person supporting the people involved in the investigation to the person actually investigating, and that's obviously going to depend on resources. But thinking about, I guess, the process of an investigation a little bit differently, to try and make sure that people are feeling supported throughout, and just thinking a little bit differently about the way where we're going apart through things. The other, I guess, things that are really changing is the outcomes. So let's say you have a complaint, you investigate, you get to the end. I guess the decisions that are made about disciplinary outcome are changing. So I think gone are the days in terms of sexual harassment where there are sexual harassment is found, for instance, and someone is not terminated on that grounds when it's really serious, and they go off to, they're an executive, let's say, and they go off to more corporate training, they get a warning and they continue in their role. I think increasingly people are looking at this as a, well, hang on, why shouldn't they be terminated? Let's look at all the circumstances, sure, but why shouldn't they be terminated? Because of how serious this conduct is. So that's the other piece that I'm seeing a change to, is more businesses taking a stand as to what inappropriate, where the line is for their business of inappropriate workplace behaviour, which has been a definite step change since the Me Too movement. So just a bit of a summary of what we need to think about. So in taking disciplinary action, the upshot is a breach of a social media policy will generally constitute a valid reason. You still need to assess the fairness of the proposed termination for a policy breach against a wide range of relevant factors, and that is a lot of that we've discussed today. But I think courts and the Commission are more willing to hold employees accountable for social media misuse. There is still a line, though, and you should really exercise caution in these three areas: where an employee's conduct or opinion is exercised pursuant to a right conferred to them in a particular workplace policy or instrument. So, for instance, where there's a workplace delegate, or where that person is also has some sort of role in the union, for instance, it's worth going to get some advice about that. Where the employee's conduct or opinion is a product or is linked to an attribute protected by legislation. So think of Folau and his religion, or some sort of political opinion, and some of the examples that I talked about before, or where there is not, or you're not sure whether there's sufficient connection to the workplace. I think in those circumstances, it's worth going back to the test in Rose. It's worth having a look at it, and it's worth getting some advice about where the line is in the case law, just to guide you a bit as to what the legal risk is. Now, as I said before, obviously legal risk is one piece where businesses are looking at in making their decision. It's worth being mindful of, but I have seen businesses still take the position and still decide to terminate, notwithstanding a higher legal risk, because of the broader reputation. And obviously every case is different, but that's how I analyse these things, is looking at those particular circumstances, looking at it against the test and the current case law to guide clients on which way to go. So what I'm recommending is having clearly communicated, so training people in clear policies on out of hours conduct, conflicts of interest, and social media, and targeted training. Be really careful with employment related events and trips, and external and work type trips, to communicate the parameters of the event or trip and the extent to which workplace policies apply. And the reason is we do see a high incidence of events that come across my desk for those sorts of situations, particularly where there's alcohol involved. Having thorough and documented investigation and consideration before decision making, and careful consideration of the elements, as I said before, the application of the Rose test and how it's been dealt with in those circumstances by courts and commissions before the decision making is undertaken. I think all of these things, it's not an easy area. Sometimes there'll be easier ones that come across my desk, and sometimes there's harder ones. And I think a lot of this is balancing, I guess, the values of the organisation against the behaviour that's in front of us. But I don't think we've certainly seen the last of the case law in this area. I think cases like Folau that have ended up settling, we were really expecting a lot of those cases to really set the scene and set the bar in these sorts of areas, and the guidelines for employers and employees on what can be regulated, but we certainly haven't seen the end. Just wondering if anyone has any questions before we wrap up.
Just a friendly reminder to our delegates, if you do have any questions, you can submit them via the Q&A button to ensure that they're answered. We'll wait a moment to see if any questions do come through. Just while we're waiting, Wendy, did you have
Yeah,
any last words of wisdom that you want to impart to the delegates just before we close the session out?
I think I've actually done this presentation a few times, and it was interesting because the last time I did this presentation in the interim, there've been two cases in this area. So I think it's really worth, if you are in a situation where something comes across your desk where you need to analyze out of hours conduct, it is worth having a look at recent cases in the area because it is actually developing quite fast. So I'd really, I don't think I think the Rose test is here to stay, but certainly given developments in social media, in the way that we're all working, such changes in people working from home versus in the office, I think changes in people's resilience since COVID and changes in our the community's expectations of what is right conduct and what isn't means that this is definitely going to be an area where we're going to have to keep tracking pretty closely, I think. But it's a really fascinating one, I think.